Good afternoon. I'm Deb Van Dyke Reese, and I'm the director of the Nebraska Court Improvement Project. And it is my pleasure to start our 2022 education with Michelle Paxton and Laurel Johnson and their talk today about using multidisciplinary experts to improve juvenile court advocacy. Before we turn it over to Michelle and Laurel, I wanted to do a few housekeeping items. So we would like really encourage everyone to mute yourself so we can make sure that Michelle and Laurel don't have any feedback. And we are recording this webinar, and if you would like to view it at another time or send it to others that you might think would be interested in this topic, we will have this webinar recorded on our YouTube channel, on the CIP YouTube channel, and we'll send out that link a little bit later this week. The final thing is that this webinar has been pre-approved for CLE credits, and we will drop that activity number in the chat towards the end of the presentation. The chat is a great way to communicate and ask questions of Michelle and Laurel, so please make use of that, the chat box. A couple of other things I wanted to just kind of put on your radar is that February 16th, this is a save the date for our annual legislative webinar, which will be at noon. We will be sending out correspondence about that in the next week or so, but we invite people to share kind of highlights of bills that are related to child welfare and youth justice that are being debated currently in the Nebraska legislature. And the final thing that I'd like to do is have you all save the date for the Children's Summit, which will be September 13th and 14th in Kearney this year. And so again, correspondence will be coming out in the near future on that. So I am going to turn it over to Michelle and Laurel to start our presentation. Thanks for being here.
Thanks, Deb, so much. We are very happy to be here today online to chat with all of you, wherever you may be at in our state or wherever I'm joining remotely. Hopefully you're having some lunch or while you engage in this presentation. So we know often your cameras are off, but hopefully we can have a good conversation throughout this presentation and get your input on some things that we've been thinking about on how using multidisciplinary experts can improve juvenile court advocacy. So agenda today of what we hope to accomplish, we want to talk about how this really, the modality of bringing in multidisciplinary experts can really enhance your advocacy if you're an attorney, or if you're a non-attorney joining this one, how that can help and improve an attorney's advocacy. We want to talk about the ethical considerations that maybe when you signed up for this webinar, immediately you were thinking about ethical issues, address some examples, and then tell you about the new Children's Justice Attorney Education Program. As Deb mentioned, if you have any questions, feel free to drop them in the chat window. Laurel and I will be monitoring that, or I'm sure someone at CIP will bring it to our attention if we happen to not see it. But please drop those in there, and we'd love to engage with you throughout today. So when you thought about who is a multidisciplinary expert, or you signed up for this webinar, I'm curious at who you were thinking of. So what we're seeing nationally, many states are implementing multidisciplinary models in child welfare and youth justice. So you might have heard about this. The most common model, or a very popular model we're hearing about, is the partnering between a lawyer and a social worker. So lawyer, social work team, representing parents primarily, but sometimes also representing youth. When we think about multidisciplinary expert, I love that model. I think it's awesome. If you're curious about it, we're intrigued and love to bring that to Nebraska, but we don't want to limit the idea of a multidisciplinary expert to a social worker today. So I want to expand our definition to think about anybody outside of your case that brings expertise. So the list is expansive. It involves a social worker, a therapist, psychologist, lawyer, tribal representatives, former case managers, and individuals with lived experience. The key piece is that they are outside your case. So they're a non-party to the case. So we're going to try to be super fancy and do a poll today. You guys thought you'd just be able to sit back and enjoy, right? Well, maybe you still can. I won't know if you're the one ignoring the poll. But if you would, and tell me if it's popping up for you, there should be two polls being generated on your screen. One is, how often have you used a multidisciplinary expert? And then, who have you used? We're curious where this is falling for all of you. And thank you, Tracy. Kudos to her, because I do not use WebEx in my professional world, and so was not familiar with the platform for polling. So rock star being able to get this going for us. And we'll give it a minute to see where the numbers fall for all of you. For what it's worth, those who do this kind of thing ever in their work, a polling via WebEx is kind of cool, because over here on my screen, I don't know if it shows you on yours, so this is always like me talking to myself. It shows how many of you have done it or are working on it. Like, technology sometimes impresses me so much. Oh, so someone just shared it only let you pick one person. So if it only picked you one person, like you can only pick one, first of all, our error in polling, but go ahead and type it in the chat window. Like, there's no rule that you can't type in the chat window there. We were just trying to come up with a fun way to engage with you and get that kind of the dialogue going. So if you've consulted with other experts on your cases other than the one you picked, because it only limits to one, go ahead and type that in the chat. I'm going to close the poll, and I have to wait for responses. Never mind. Oh, now I can share. Apply, maybe. Can everyone now see the results? Oh, thank you for that. No. So interesting, we kind of have across the board a nice variation. Honestly, a lot of people know answer, so that's okay. But some people saying I use it on a regular basis, but most often saying monthly, once in the last 6 months, never. So across the board, a lot of variation in how often we're consulting with a multidisciplinary expert. And then interesting, the most common result that I'm seeing is a therapist. Now I want to remind you and challenge you, is it somebody that's not on your case? So not involved in the actual case. And that's an important piece there. And we'll talk about more why later. It's important that our multidisciplinary expert is someone that isn't a party to your case. So some great responses here. Someone said, I use everyone. I'm a former CPS worker, so I have those great connections, which is wonderful. Someone also wrote neuropsychologist. I love it. Therapist, social worker, experts. I love that. So someone else mentioned here, thank you for doing this, Melanie, medical expertise, like a home health PT, OT, so other medical folks. And we didn't have that on our list, but based on my definition, that's included here too. So thank you for putting that in the chat window. So why do we think this is important? Easy. It changes outcomes. And I'm not talking little changes. I'm not talking as a lawyer, it makes your life a little bit easier because you have someone else doing the heavy work for you. I'm talking it changes the big outcomes for children and families. So when we've been looking into this, and fortunately some of this new project has led us, that we're going to talk about, I promise, but has let us do a deeper dive in what we're seeing in other states and some of the research. Laurel and I are meeting and going, what? Are you kidding me? That's fantastic. So, Laurel, would you talk a little bit about the research studies with Casey Family Programs in New York and kind of what they did to assess the impact of utilizing multidisciplinary consultants in their work?
Absolutely. And as Michelle indicated, this is a model that is being implemented nationally. And so there's a lot of good examples already that we can see in terms of how multidisciplinary consultation is impacting cases. But in this specific study that is being referred to, Casey Family Services partnered with New York University and Action Research to conduct a multi-year study of child welfare cases in New York City. And in this case, they were looking at parent representation, and they were comparing solo practitioners or folks who were taking court appointments and handling those independently with lawyers who were part of a multidisciplinary team. And they were able to conduct some really thorough research since this expanded multiple years. So in the next couple of slides, we'll talk about some of those outcomes that were found from this particular study.
And Laura, while we're mentioning this study, there are other states across the United States that have implemented different types of models that are coming up with the same results. But we want to highlight a few of those. If you were at all thinking like, okay, I'm going to this webinar and and I don't know if I need this or why is it important? Let me throw these at you. 4 fewer months in foster care. Now, for me, 4 months is not a big time in my life. Like there's not a lot that changes other than the seasons. But I think about an 8-month-old and the developmental stages between 8 and 12 months. Huge. Going from maybe rolling on the floor to full-blown walking to different foods and all these things. So many different things happen in 4 months. So in the life of a child, 4 months is a big deal.
I think too.
Oh, sorry, Laurel.
No, it's okay. I think this is like a less, we don't often want to talk about this component, but it's still a selling point for this model and still a positive outcome. And that particular study cites that because of the 4 fewer months in foster care, this saved the city of New York $40 million because out of home.
Can you say that number again, Laurel? How much money did it save?
$40 million is the amount that was saved by these children being in foster care for 4 fewer months on average in those multidisciplinary teams.
Phenomenal. And because sometimes when we identify these ideas that would serve children and families better, the question that other stakeholders will ask is, we don't have the money for that. And sometimes it's recognizing that we just need to shift our money and actually we'll save money by thinking about things differently. I thought this was fascinating that reunification was happening 43% more often in the first year in your multidisciplinary team model. Huge numbers there of change that we're seeing in that model. 2 times as likely to be in a relative placement within that first year if there was a multidisciplinary team working on that case. 2 times as likely. And they were overall, when they looked at all the cases in general, you were less likely to have a termination of parental rights filed when there was a multidisciplinary team working on the case. So, we only pulled for you guys, because we can't be here all day. I know you want to, but we can't. Some of the statistics we found impressive. And Laurel, you were digging into this and you represent parents and children and have worked in child welfare and youth justice for quite some time. Looking at these statistics, what struck you the most when you're thinking about the cases that you served on?
Well, I think all of these statistics are very eye-opening and very significant. But when I think about a 43% statistic of more often having reunification as an outcome, that is, to me, the most fundamental difference that our cases make if we reunify families or if there is a different type of permanency objective. And if it's happening 43% times more often, in cases where there's the ability to utilize multidisciplinary experts, that's pretty substantial, and that's pretty important, and that's impacting, as I indicated, the most significant and substantial right that I think parents and families have.
Absolutely. And I think of when we look at these stats, someone asked me for permission to annotate, and I don't know why I said approve. I don't know what that meant, y'all. But so why these results? Why do we think this is happening? And immediately when I was thinking about this, I thought of this episode of Friends, which Laurel and I had banter about if this is Joey or Chandler. So we'll tell you that this ages us and the different ages of both of us. But this idea of, as lawyers, you guys, those who are lawyers on here, we're a lawyer. We've been trained to think like a lawyer. Our brains process information as a lawyer. And as much as I love, thanks, Jill, totally, Joey, to think that I've facilitate conversations or connect with therapists or social workers or psychologists, and I've learned from them, I haven't been trained in that place. That's not my expertise. So I can put on as many layers of clothes, like I'm the therapist or I'm the social worker or I'm the whoever, but I'm still a lawyer underneath. And I think of Judith, who posted in the chat window as a cultural advocate, is a great example of a multidisciplinary expert. I can understand and study the Indian Child Welfare Act. I can work zealously on those cases. But a cultural advocate brings on a different hat, if we want to look at it like Joey's with his clothing, to look at the case, and we'll be able to look at the case through their lens and not mine. And that really is what we're seeing with some of the impact on these cases. Now, Jill just posted in the chat, and I'll pose this to you, Laurel, if you happen to remember. If not, we can circle back with you, Jill, is if they were able to see in any of these studies the recurrence of abuse or neglect and new filings on cases that had a multidisciplinary team. Do you recall that data?
So I think, to be 100% certain, we'll circle back with you, Jill, but I know, and I've reviewed a lot of these studies, but I know that part of what stuck out to me about this in particular is that it went multi-year, and so it could look at that reoccurrence. And so I do believe that that was taken into account, and it's cited on this if you're interested in looking at it, but I can definitely get back to you with more specifics.
And there was another study, a quick done out of Michigan, Jill, with Don Duquette, and I feel like my memory tells me that that was a piece that they also studied. That was a lawyer social work model. And they found that there was less likely to be another filing in those cases, whereas there was that pairing. But that is a great piece of data that would be worthy of looking into. Now, for my lawyers on this webinar, my guess is that some of you may be percolating in your brain ethical issues. How can I, when I have these ethical guidelines that I must follow, I don't want to get sued, I want to do good work, how do I do this and not violate those ethical considerations? So I don't know if this is enough of us to get an ethics CLE, but I do want to talk about ethics because this is a very important piece when we think about utilizing multidisciplinary experts to enhance our advocacy. So Laurel, will you talk about kind of the current, your assessment of the language and the feedback we've gotten about utilizing multidisciplinary experts?
Yes, absolutely. And so most lawyers, when they think of ethics, we kind of know Rule 1.6 without even looking it up or referencing it. And for me, at least, that was something that was drilled into me in law school, and I kind of took away as my most important obligation to my client is to protect confidentiality, and that I must abide by that kind of above all other rules. So the rule itself, which is also a Nebraska rule of professional conduct, indicates that all information relating to representation of a client is confidential and cannot be disclosed except where the disclosure is impliedly authorized in order to carry out the representation. So what does that actually mean? Well, based on the poll that most of you participated in, and based off of my own experience, none of us practice law or make decisions, especially when it comes to best interest or risk of harm, none of us do that in a vacuum. And nor do we really think that that's best practice. But how do you balance your obligations of confidentiality to your client and also being able to carry out representation and further that representation? Well, fortunately, the American Bar Association has weighed in ethics opinions that provide guidance and point out that lawyers can and should ask and should discuss case information, subject, of course, to limitations, but when that disclosure furthers representation. So in other words, when experience or expertise of others helps their client or helps the goals of that representation. We all benefit from expertise of others, and the American Bar Association interprets Rule 1.6 to allow and encourage for this, actually, when we use general and non-identifying or hypothetical examples. So it's actually something that the Bar Association wants lawyers to be doing, that they want us to do the best work for our clients, and that can't all just be doing research or looking at case law, and those are all important components, but especially when it comes to juvenile court, our representation is really enhanced by relying on other experts, and that's encouraged. So for purposes of discussion in this presentation about multidisciplinary professionals, in Nebraska, the Council for Discipline believes that this extends this furthering representation and implied authorization. They believe that this extends to other professionals. So that therapist, that social worker, tribal representative, or whatever person with specialized knowledge about substance use or mental health, or whoever it is that we rely upon, that Nebraska Council for Discipline believes that it's within our ethical obligations and that we're in compliance with that when we have consultation, as long as we're not giving identifying or obvious case specifics, and as long as we're remaining as general as possible. So what are some of the challenges and some of the benefits when it comes to this model when we think about ethical considerations? Well, first, all professionals have their own ethical guidelines and codes, and that's based off of their own professional obligations that their own profession may have, just like we do as lawyers. Second, using general and non-identifying information doesn't always happen. I think we all have an example, whether it's something that we ourselves have shared or something that we've observed when parties are sharing too much case information or talking openly about cases. And this is in no way to encourage that, because that's absolutely not appropriate and not in compliance. So when we're soliciting advice from other experts, we do need to be general, and we need to use information that's not identifiable. So even if we're not saying names, if the information that we're going to provide is going to give away what we're talking about, whether it's a high profile case or something that's identifiable, then we can't be discussing those things with people who will know who we're talking about. The third challenge that I would raise today is that I know that identification of appropriate consultants, one, the identification, I think, is sometimes difficult to find who is the expert I want to consult with, and two, getting people to just share their time and expertise can be limited when they're professionals who are making a living. And as Michelle indicated, we think this is a model that would ultimately be great for Nebraska, and that we've implemented into our program. We recognize that that's just not always available if a practitioner wants to go and consult with an expert. But in terms of the benefits, I do think that it's worthy of re-noting that on a national and global scale, there's a lot of evidence so far to support positive outcomes for this type of teamwork. And we gave some examples of parent representation in the parent social work model, but this is happening with agencies that represent children as well. And that's indirect representation or a guardian ad litem role. Secondly, in terms of benefits, I'd say that as Michelle indicated, and as the picture of Joey, not Chandler, Joey, indicates the insight of other professionals can enrich an attorney understanding, because we're not experts in all of the different areas that our cases call for. And so many times I felt like we're asked to make decisions without have the decisions that maybe are actually medical, or they're actually therapeutic, or ABC. They're things that lawyers aren't necessarily trained in answering. And then I think maybe one of the most compelling benefits, at least to me, is that when we can solicit advice or consultation from another professional and bring an informed decision to the table, I think that does reduce a power imbalance that takes place in cases. I know for many cases that I've been involved in, we rely so heavily on a therapist. Maybe it's the child's therapist, and what is your position on when reunification is safe, or some other type of safety assessment. And that weight is it's really not balanced, and it's not, at least in terms of representing my parent clients, I've always felt like that is so much weight given by one professional who's involved in the case. And if there was someone that's able to talk from a perspective of how this impacts parents or just other dynamics outside of the child's therapist or whoever it is in the case we're looking to information from, if we can have more voices and a more comprehensive understanding, I think that does shift the power balance. And I think that's important.
Thanks, Laurel. I think that when we think about the ethical considerations and how to manage them, the law and our guiding bodies really have reinforced that this can improve our advocacy. And then kind of the question Melanie posted in the chat room really gets to this issue is, how do we do it? And so in case you're not reading the chat, Melanie was getting at what's a funding structure? So I want to be clear about two things, and I don't have all the answers, and I have a lot of lofty goals. So watch for this. But so Melanie, what I can tell you is in your states that have like a parent attorney, a parent social worker model or other experts that they can bring onto their cases, either for the parents or for the child. First, some of the funding comes through 4E funding. So they draw down 4E funds. And I am not that, Deb and I have talked many times about my limited expertise in 4E funding. Like I get my head wrapped around it and then I bring it up again and I have to reread everything. So drawing down 4E funds to supplant that representation to utilize that. We also learned, Melanie, and we're like, what? That in these other states, there's a state fund, slush fund, or if that's not the right PC term, state funding for these additional experts. And so there's a pool of money that an agency will manage, and then attorneys come in and say, I want a social worker on my case that partners on my case, is what we found in some states. So they bring in that social worker that works with that attorney just on as their team, or the child representative. I know, Melanie, right? Like, I feel you. And then, or the other option, I was like, what? This is happening in other states. You guys are driving me crazy. And I was so jealous at the same time. Was that the other option they have is they have like an expert fund. And so, Laurel, if I'm misrepresenting what we understood, but so then you could consult, you could say, I want a forensic psychologist. I want this on my case to do some enhancement, to do a further, not what the department is doing, not doing a trauma assessment for the purposes of the improving child-parent relationship or addressing the trauma, or a psychological evaluation, IDI, to determine services for a parent, not something that would go with under the department, but in order to enhance advocacy for that parent or that child. So essentially being able to consult with someone else on that case that can be part of your team, that then you could either have in a limited capacity, you could do either limited capacity of consultation to better advocate. And we're going to talk about that with some examples next. So thank you for that transition. Or bring them in as an expert to testify. So if you felt it warranted at some legal, some hearing on a variety of issues, you could bring in that expert to testify. And that came from state funding. So I don't think it's off the board that we could explore like that something in our state. This is a great time for us to be talking about it and mechanisms to do it. And I'll tell you, there's a 4E sub work group that is working on that very issue. And these are the kind of things that I think members of that committee agree would supplant, your legal representation to make it better, which is really cool. So now that I got y'all to drink the Kool-Aid, let's give some examples on how we think, like as a practical matter, it could help. Now, I do want to note in Melanie's question, she talked about, I'd like to have the child's therapist at the family team meeting. I agree with you on that. That's kind of not necessarily the scope of what we're talking about here, because they would be a member of a party to the case, essentially, because they represent somebody, versus what we're really thinking about is bringing non-party experts into your case to consult. I do think there's mechanisms, and that might be another conversation, Melanie, about how do we more thoughtfully, or is there a mechanism to bring in therapeutic parties, therapists, psychologists, others that are providing a service in the case to ensure they're being compensated like they deserve for their time to engage in our representation. So,
and Melanie, I would add too, I think in no way do I want to discourage or despair the great advice and great guidance that we get from children's therapists in these cases. Like that's, that needs to go along with any other professional that we're tapping into, because that's, somebody that can have their finger on the pulse of child safety and child comfort is going to go a long way in all of these cases. I think my point is, so many times I have felt that we rely on that person so strongly. And if we could just look outside the box, or think outside the box a bit about what other things are there to consider when we're looking at placement of a child back in the home, besides a therapist saying they're ready or they're not. Because in so many cases, I feel like a court's decision has kind of come down to that, and we're all kind of waiting for that. So my example is more so just to enhance that, or challenge that, or supplement that with other thinking and coming from other directions and lenses.
I think that's a great point. I'm glad you said that, Laurel, because I don't want anyone to leave this presentation thinking that we don't think that therapists and providers on our case are instrumental in helping us advocate as attorneys, or helping us provide effective information to the judge to issue thoughtful orders, right? We think that when you can consult with people outside your case, you can even do better. So we actually have a couple of great examples I want to run by with you all to kind of get our brains percolating on this. So Laurel, you had a case where you ended up doing a multidisciplinary consultation. Would you kind of run through these facts about what was going on in the backstory? Of course, hey, non-identifiable information. Here's what you kind of presented. Talk us through this.
Absolutely. I had a case where I have been involved as guardian ad litem for young children who are in a guardianship that the juvenile court has ordered and kept the guardian ad litem on. And so I continue to be involved in that case, not too substantially, but I'm still a party to the case and involved, and do a report, have engagements with the family, visit the kids. In this case, the Indian Child Welfare Act applies. The mother of these children, and my example is really specific to the youngest child, but the mother was engaging in substance use treatment for the first time, at least for the first time, with her period of sobriety being months or a substantial duration, for the first time in years and years. And so she had achieved a period of sobriety, and she was in treatment. And one of the providers that she was working with called the guardian and indicated that they were going to start child-parent psychotherapy, and when could they set that up. And this is the structure of our treatment facility, and this is how we do it. So let's get started. So in this particular case, because of her inability to achieve sobriety during the court-involved case where the children were in the custody of the department, the mother really never formed a substantial relationship with the youngest child. She wasn't engaging in visits, and she wasn't forming a relationship in any way. She wasn't even seeing the child, so maybe had met less than 10 times in the course of the case. And this is a case that was open for several years before the ultimate permanency disposition was the guardianship under the juvenile court's jurisdiction. So services were put into this case for a long time without any of the parents ultimately able to have the success to reunify with their children. So when the guardian let me know that the treatment facility had indicated they were going to start the service, the guardian was really unaware of what the service was. And when she explained it, or when she explained to me that this was going to start, I thought, this makes me uncomfortable, and I'm worried about how this is going to look when this girl who's now 6 doesn't know her mom, or doesn't even really understand. You know, she's beginning to understand, and the guardian's really open with her that she has 2 moms. Because she's been with the guardian essentially since birth, so that's who she calls mom. But she knows she has a biological mom, but she's never met her, doesn't understand a lot of things about her. And the guardian was open to starting the service without, I don't think, really understanding what it was. And I was just left feeling sort of uneasy about if that was the best course of action in that case, and it was weighing on me. Trying to look at it from multiple angles. So I was struggling with if I needed to do anything, or if that was the best course of action for this little girl.
And so I just want to stop right there, Laurel, because I'm guessing for those on this webinar, many of them might have read these facts, heard you talk, and had a gut reaction about next steps. And I bet it is a variety of positions on the pendulum of what to do. But you felt, it was my impression, a little paralyzed, and felt like it was a big deal of those next steps because it really could impact the well-being of the child. Is that right?
I did feel like it was a big deal because I'm so familiar with child parent psychotherapy in my court-involved cases, and it can be pretty involved and pretty intensive, and would require substantially more contact than this child's ever had in her life with her parent. And then, just to be totally transparent, I'm concerned, or was concerned, am concerned about the track record of the parent, and if this was the ideal service at this point in time, given that historically there wasn't a lot of long-term sobriety or stability.
Right. So one step, you decided to do a consultation. And so would you kind of talk through with those joining us today about who you consulted with, not their name, but like the credentials, which is on the screen too, how that went, and then how did it help? Like, what was the result?
Yeah, absolutely. And I'll say, just like the person in the chat had indicated that they were a former caseworker and had those good connections, I was really fortunate that someone was able to offer me their time, and I don't take that for granted, but I was able to talk with a licensed independent mental health practitioner who has done child parent psychotherapy, who's done the assessments and provided the service, and so has substantial experience with that. And I was able to give this individual the general facts of this case and talk about the service that was being offered, or the plan for service, my uneasiness with it, and just kind of talk through where the case was at and what was going to transpire from there.
And this provider that you talked to, they didn't tell you what to do, did they?
This provider did not tell me what to do. This provider really broke it down, and it, you know, for me, it helped. It was humbling because I think I've probably had over 100 cases where child parent psychotherapy is offered, and yet I really needed it broken down for me, and I really needed the experts to talk with me about the purpose, the goals, the process of child parent psychotherapy, and what that looks like, and what typically the desired outcomes are, and what is likely to happen throughout that process. Because I I may be involved with it tangentially, but again, I'm a lawyer and that's not my area of expertise. And I really was looking for more substantive information, and so that I could make a decision about, or at least I could be informed about if this was best practice or not.
And then how long did you meet with this or communicate with this expert? How long was the conversation? 3 hours, 4 hours, a day?
20 minutes. I'd say 20 to 30 minutes we talked.
And probably because there was some chit chat about other stuff in between.
Absolutely.
With that call, because I know you well enough and I know the provider.
Yeah.
So, I mean, 20 minutes.
I was 20 minutes of talking about the case information and bouncing ideas back and forth.
And how did that help? How did that impact I don't want you to go into the details of the case, but did slowing down to talk and take that 20 minutes to consult with that expert, did allow you to speed up in thinking about what your next steps would be, or how to approach the case, or additional action advocacy pieces that you would do?
Absolutely. I was able to gain from it a more informed perspective. And so then I was able to weigh in as the advocate for this young child. I was able to have a conversation with the providers at the treatment center where I just felt like I had more information and understanding. And that was able to kind of help guide the questions that I had for them and guide the conversation, because we were on a more equal playing ground about the service. I wasn't in a position of my feelings are that this is a good idea, or my feelings are that this is a bad idea. I had more facts and I was more focused on the service at hand and the potential outcomes. And actually, based off of that conversation, we both came to the conclusion that it wouldn't be appropriate at this time to provide it. In fact, the provider said, we realized that actually this wouldn't even be ethical for us to provide based off of some of the case circumstances. But we were able to form some really good next steps, and potentially we'll get to the point where that service is being offered and is appropriate. But I think based off of the consultation that I was able to have with the expert, that I was able to bring to the table some better perspective, and then we were able to do some better planning.
And what I love about what I'm hearing you say is that you had this conversation that helped you, I'm translating here, have a more collaborative conversation with the provider instead of being pressured, because when we're pressured, we get defensive and the lawyer, at least Michelle's lawyer voice comes out. Instead, it becomes a cross-examination instead of a conversation. And that slowdown ended up not leading to a court hearing where people were arguing about what to do, but actually you were able to bring people together to be on the same page. 20 minutes. Go, Laurel. I love it.
Well, and I think too that 20 minutes, in this case at least, potentially was able to save further litigation or court filing to try to achieve something that could be resolved, at least at this point, just by conversations and careful planning on next steps so that everybody's expectations can be managed and move forward.
Right. I want to talk about another fact, but I do want to, one other thing or scenario I want to mention. While I acknowledge I would love those who are out there saying, we want the lawyer social work model. We want a pool of experts to bring on our cases. I'm with you. We just don't have the state funding yet. We don't have 40 drawdown. I don't have a big grant. I'm willing to write one for y'all. Love it all. Okay. In the meantime, here's what I tell you. We're going to talk about the CJ, but if you're not in that program, don't rule out that people are willing to help. The same way that if you have a social worker, a therapist, as attorneys, I get them to call me all the time and say, hey, Michelle, what as a jail, how do I talk to a jail about this? Or what do you think about this? And I'm happy to talk to them. Don't be surprised that people are we are in this profession because we want to help. And I think it goes both ways. So they want to do that too. Don't rule people out that they don't want to help and offer their guidance. So another scenario to think about, I think this is common, and I've been hearing about this in different parts of our state. So we have a parent struggling with substance use, not engaging in treatment or testing. And the department stops parenting time and says no parenting time until they test and test negative. Jill posted, is this happening? Jill, it's my impression it is happening across the state in different areas. So these are our facts. And so what I want us to kind of talk about, though, is the ways that multidisciplinary experts could play different roles depending on those facts. So thinking about this, if I am the attorney in that case, I am representing the parent who isn't complying with their court orders, right? They're not drug testing, they're not going to treatment, and then we've cut off parenting time. If I go talk to a social worker, what could I talk to them about? So I think in the list that we put on this slide, you guys, I'm sure many of you would add other professionals, but I think about things like, talk to me about a parent-child relationship when a parent's using substances. How does that impact a parent-child relationship? How could safety be ensured? What would be mechanisms to ensure safety if a parent is under the influence of substances? Maybe if I had a former case manager, I could say, what is the department policy about parenting time and how to ensure safety? Sometimes I have been, I'm trying to think of the right way to word it. There have been instances in my career where I am told that it is department policy when the actual policy, when you read it and dig into it, says something different. The caseworker, good intention, but maybe didn't understand it, didn't read it thoroughly, and was just told that's a policy. Okay, but let's really look at that policy. So consulting with a former case manager who can help you access department procedures and policies or best practices nationally. Maybe your therapist can talk about benefits. If it's a therapist and you want to think about, I'm the parent's attorney, but I want to know, how does it benefit children, just generally speaking? Even if their parent is using substances, how does it benefit them, the child, to still see their parent? There is research out there that talks about this kind of thing. Maybe they can provide you documentation that you can offer an exhibit to the court about these things. These different experts, their brains might have an expertise that could enhance your knowledge about engaging in parenting time, even if a parent is struggling to maintain sobriety, right? So that's their zone. Do you go to the social worker and say, well, I'm an attorney, what motion should I file? How do I challenge this to the judge? We all know the answer is no. Like maybe your social workers, maybe a former case manager would say, well, in another case, the attorney filed a motion for parenting time. But no, let's talk to another attorney. That's your multidisciplinary expert. I don't want to limit it just to those with different letters behind their name. I want to call Laurel Johnson and say, hey, Laurel, got a case, want to talk with you about it. I'm representing this mother struggling with substance use. My impression from talking to this therapist and talking to this mom is that there's a really tight relationship between the mother and their child. And I'm worried that by not going to the parenting time sessions, my client is really starting to disengage from services because they feel like a lack of hope, all these other things. How do I pitch this to the court? What do I do? So Laurel, if I came to you and I said, the department is stonewalling me and saying no contact for my client with their child, and all this other information I have says that's good for the child, good for the parent. As a lawyer, I feel stuck because the department's so powerful. What would you tell me, Laurel?
So, that's where I think we rely on other attorneys who have experience filing specific motions or issuing certain subpoenas to someone within the department that it can attest to what the department's policy is. And sometimes it just takes talking through those situations with someone who's done it. So even if you've already filed the motion, I think, how are you going to structure that, and what evidence is really important to come in front of the judge for the judge to be able to make the decision that parenting time could be appropriate if that's what your goal in that situation is.
So you might be able to talk me through, what does a motion for parenting time look like? Show me an example or chat with me about it. And then how would I prove that up in court, especially if I know my judge is kind of a judge that says no parenting time if using. So what kind of evidence might that be? Maybe I subpoena someone from the department that can Maybe it's a case manager, maybe it's administrator, maybe it's the CEO. I think Laurel subpoenaed all those people in her career to testify department policy. Maybe it's an expert in child-parent relationship. It could be a laundry list of things that that lawyer could then say, I've done this before. This is how I might set it up so that when you're filing that motion and going in court to prove it up, you feel more confident in that ability and have the right resources to be effective. And Judith posted in the chat therapeutic visitation. So maybe when you're consulting with your social worker or a therapist, talk about, could there be a way, what would that safety look like? Does it look like having a therapist present, or does it look like just having an agency present, or what are the barriers there? So some ways to think about that multidisciplinary expert is more expansive than, I think, a social worker. It's your lawyer too that can be a great resource. Thanks for letting us talk about some examples. And now what we also want to talk about is a program really excited to share with you about that Laurel and I are working on. It's called the Children's Justice Attorney Education Program. This program has kind of a history to it in the sense that, for those who don't know me, I fell into being a juvenile court prosecutor back in 2006 and had no history in child welfare or youth justice and understanding all the complicated circumstances that families are experiencing. After I stepped away from prosecution, I worked with those who were training our child welfare workers, and then had this moment of a huge light bulb go off that said, why are attorneys not receiving training and support in all these areas that move beyond lawyering in court? Like, yes, I know how to examine a witness. Yes, I know how to offer an exhibit, but do I understand substance use? Do I understand what it's like for people to live in poverty? And I did not. That was what propelled me in 2017 to launch the Children's Justice Clinic here at Nebraska, which provides training and support to law students to serve as guardians ad litem. And in that, the students receive, in case you're not aware, over 70 hours of training and expert case consultation in all areas of child welfare and youth justice. So similar to what we're talking about, the students in this program, if they have that very question, those scenarios we just voiced to you, they would work with me on the lawyer side, but I'm not going to wear the hat of the social worker. I'm bringing in experts to consult with them on cases. We are all self-funded except for a contract with the county for this program. And some of our other funders saw what we were doing in our community and said, how can you expand? As I was thinking about expanding, feedback from our judiciary reported that 40% of judges said they do not have access to high quality counsel in juvenile court cases. That doesn't mean the attorneys that I think are representing children and families across Nebraska aren't high quality. It's that we lack the numbers of attorneys that we need, and some of the attorneys haven't had access to the training that they need to be successful. So we applied, the university applied for a Springboard Prize and additional funding, which was sufficient for us to launch this new program and bring on Laurel Johnson. So those of you who love Laurel as an attorney and a guardian ad litem and working on cases, I do apologize that we stole her from that direct representation role, but she's just so good that we brought her on as a project manager to lead and implement this program. So we are in the phase of developing it, and it will be a similar model. Attorneys that our goal is to recruit up to 12 attorneys annually to participate in extensive training, but also expert case consultation. So if you join the CJ, you will have access to a plethora of experts and are expected to engage with them on your cases of maybe it's an education issue of how do I advocate in IEP, or maybe it's those scenarios we were just talking about. The parent I represent, they're telling me they can't have access to their child anymore for parenting time. You will be able to consult with those experts throughout the experience in your case in the program. The program will start in May. So here is the time frame to write down on your little calendars. February 9th, the application goes live. Our goal is to make it's not time intensive. We just want to know a little bit about you, who you are, why you might want to be in this program. your years of experience, and then you must be from rural Nebraska, because that's where we're seeing the real shortage of available attorneys. Again, it's not that they're not high quality that we have, there's just a shortage. So instead of taking on more cases, they're having to drive across county lines. And so our goal is to recruit attorneys to serve in those cases. Here's the other thing. We're going to pay you for it. So we think being an excellent attorney takes time and needs additional supports. And many attorneys, when they're right out of law school or if they're starting in this new area, cannot commit the time necessary to learn all these additional skills and understanding that they need to be effective. So you will receive a stipend to be in our program of up to $5,000. So essentially, it should cover what a court appointment would be in a case of your hourly wage. You're not going to get rich in our program, but we want to compensate you for your time, and you'll be able to go to different conferences. I think that kind of covers the backstory of how this came to be. We're in the midst of developing it, bringing on experts, creating our trainings, knowing it will launch from May to January. And we want those who are interested, if you want to type your name or your email and the address in the chat window, Tracy will get that to us so we can connect with you. You can also go to our website at the university's portal and say that you want more information, and we'll follow up and make sure you have a copy of that application when it goes live. So that's a program overview. Does anyone have any questions or comments or suggestions as we are building this program? I haven't looked at who all is here, but from those that I did see, we have some amazing people joining us today. So if you have feedback for us, one of the things that we have really enjoyed is talking with attorneys in our state, national stakeholders, different stakeholders about best practices and how to bring those to Nebraska and implement those in a variety of ways. So we would love to hear from you, even if you aren't interested in being in the program, but have feedback for us on what you think would be helpful. Let us know. And it is 1:27, so that gives you 3 minutes to ask all those questions, and we'll stay on longer too. Don't worry. Thanks, Tracy, for typing in that ID or CLE ID.
And thank you, Joy, if you're still on.
I'm going to go ahead and just say thank you to Michelle and Laurel for being with us today to provide some great information about that multidisciplinary model that I keep hearing about on a national level, and still hopeful that that's something we can definitely bring to Nebraska. And so you've got both Michelle and Laurel's email addresses. So I would encourage you to contact them if you are interested in the Children's Justice Attorney Education Program. If you have any questions for CIP, you can always email us too. And I guess if there aren't any questions, I think we'll go ahead and just sign off for today. Thanks everyone for joining us. Looks like we've got.
Well, thanks, Michaela, for that information there. And if you know of anyone else that might be a good fit for the program, feel free to pass on their name to us or have them reach out to us too. I appreciate that, Michaela, for that information. We'll get your email down and follow up with you. That's wonderful.
So if there aren't any other questions, I think we'll go ahead and sign off. But thanks again for your time today. And thank you, Michelle and Laurel, for being a part of this presentation.
Thanks for having us, Deb.
Yep. Take care, everyone.